Hello, I'm David Mandell, one of the principals of the OJM Group, a nationwide wealth management firm, and also an author of a number of books for the medical industry, for the business industry. And you may have seen, as a viewer of MultiBriefs content, you might have seen my articles. Myself and some of my colleagues have been writing for MultiBriefs and their various organizations in their newsletters for 2 to 3 years. Now we're beginning in 2017 to supplement those articles with webinars. And this is the first webinar. So if you happen to find your way to this webinar and you find the content valuable and you want to see more of it, feel free to contact your organization and maybe even tell them to let MultiBriefs know that you'd like to see more of this. Our thinking is we will do these on a regular basis and do different topics. So today the topic is going to be Asset Protection 101. And while I am, as I mentioned, a principal of OJM Group, a wealth management firm, I'm also an attorney, and I've been practicing law for about 20 years. And asset protection is the area of law that I've practiced over that time and helped hundreds and hundreds, if not thousands, of clients in these areas. And I look forward to providing some of that information and some of that knowledge to you today. So like any good lawyer, we've got a couple of disclaimer slides. And essentially what we can boil this down to is this is not legal advice for you. This is not tax advice for you. You should be advised by proper professionals who are licensed. And what that means is today is really a good time for you to be opened up to some of these ideas, to take some notes, to think about how this might help you. And maybe you can take the next steps after you listen to this, and we'll do this in about 45 minutes to an hour. Now, if you've seen any of our articles, you know that we also write books, and we're willing to provide those to members of organizations who use MultiBriefs for free. So I think the two most relevant books for many of you listening might be Fortune Building for Business Owners and Entrepreneurs, which is a good general book for those who own businesses, and for Doctors Only, for those physicians out here who are listening, who are either employed at an institution or own their own medical practice. So at the end of this webinar, I'll tell you how to get those books for free by being an attendee today with a special code. So just stick around and I'll give that to you at the end. So in today's presentation, this is what we're going to accomplish. We're going to talk about common liability traps and why asset protection is important. I'm going to give you the background of asset protection, the sliding scale, and really sets the tone for how to evaluate asset protection planning. We're going to talk about business or practice asset protection planning, how to protect a business and its key assets from lawsuits. And then we're going to talk about cash flow planning, how to protect cash flow from claims and lawsuits. And then finally, personal assets like your home and personal investments and what your options are there. So let's jump in and look today first at the common liability traps and why we need to protect assets. Now, if you read our books, if you heard me speak at other places or read any of the other articles, you know I'm not someone who says the sky is falling. I don't think that you have to get yourself in a panic and keep yourself up at night to wonder about, hey, you know, all the different types of liability I could incur, and I should really be nervous until I protect myself. On the other hand, if you have a business, if you're in a professional practice, if you're a physician, we have to come to grips with the reality that liability is out there, and it's likely at some point over your business or over your medical career that you're going to be sued. And when you get sued, it's certainly going to be an emotional experience. It'll probably cause a high level of stress, but it'll be a lower level of stress and a lower level of concern if you've already done what you need to do to shield the business, to shield your personal assets. And the good news is, and hopefully you'll get that today, is asset protection planning, the multidisciplinary process of positioning your business or personal assets in a way that they're best protected from future lawsuits and claims. That process doesn't have to be overwhelming. That process of asset protection doesn't have to be expensive. And in fact, in many cases, it can actually turn into a positive, even if it doesn't have to be relying on, I mean, even if you're never sued, because it may force you to do some savings, it may force you to save some taxes, it may force you to create a better estate plan. So there's a lot of other side benefits related to asset protection planning, and I think you'll see that today with some of the examples. So, but why do we need to protect assets? Well, certainly your business, if you have a business, is going to have some types of liability. You may have employees, the second bullet point here, where you could be sued personally, or the business could be sued for harassment or wrongful termination or violation of a fiduciary duty or HIPAA violations if you're a medical practice. Whatever it is that your business does, it can create liability. So if you're a physician, that's malpractice. If you're creating a product, that could be product liability. If you are engaged in any kind of activity at all, almost, you could be liable in a tort action like negligence or what have you. So, you know, in the U.S., there's no way to be operating businesses and not have potential liability. Now, many of you may also own real estate, and premises liability is significant. I've had clients sued because of slip and falls, because actually I had one client in New York when I was practicing law who was sued because a police officer was following a suspect in a chase and came onto their grounds and got injured, and they sued them. So, you know, whether it's slip and falls or my environmental claim, there can be significant premises liability. And then there's personal liability that just goes beyond that. That could be car accidents. That could be dog bite. That could be people getting injured on your property, or because, you know, you have a party and they drink alcohol and they get into an accident. So there's a host of reasons that you could have liability, and I think the key is just to recognize that, operate your business or your practice as carefully as you can, but regardless of how careful you are, that liability still potential exists. So what I tell clients is aim for the best. Be a risk taker if you're an entrepreneur. Go for a business that's expanding or whatever your personal goals are. But at the same time, plan for the worst, meaning spend some of your time, 1% of your time, 2% of your time, thinking about what could go wrong and planning to put yourself in the best position against that. This still means 99%, 98% of your time should be looking forward, but a little time looking backwards and making sure that you're in the best position you can be in case something goes wrong. So that's what asset protection is about. That is exactly the goal of asset protection planning, is helping clients put themselves in a position, if they ever have liability or lawsuits, creditor claims, that they are in the best position they can be vis-a-vis protection. And in the books that we've been writing for about almost 20 years now, we've been using this sliding scale. We use a -5 to a +5 scale. You could certainly use 0 to 10. Now, if you put 10 asset protection attorneys in a room, they probably would agree on the two extremes, -5 and +5. But they might disagree on the nuances in between, and that's okay. This is meant to give you an overall picture. Whereas -5 is an asset that has no protection whatsoever. If someone has a judgment against you personally and you own an asset in your name, it's totally exposed. It can be taken. If your business, say a corporation or an LLC, has a judgment against it and it owns an asset, that can be taken by a creditor or lawsuit against that entity. So -5 is really the asset being owned in the entity or person's name that we're trying to protect against. At the other end of the spectrum is +5. These are assets that are truly off the table. I don't like to use the word judgment proof, but they're off the table in terms of a creditor or lawsuit claimant being able to get them. And these are generally state and federal exemptions. We'll talk a little bit about that later on. Some types of trust, perhaps if you've made the gifts to the trust and they're irrevocable and you have no strings attached, etc. So, but in general, the +5 tools are going to be state or federal exempt assets. Now, in between the -5 and the +5 these are the tools in between certain types of ownership, like tenancy by the entirety, TBE, LLCs, limited liability companies, FLP, family limited partnerships, certain types of trusts, like domestic asset protection trusts, otherwise known as DAPs, These are tools that attorneys play an important role in bridging the gap between the negative and the highest positive +5. Very interestingly enough, the +5 tools generally aren't set up by lawyers, and we'll talk about that later. So the best protection you can get, you generally don't go to a lawyer for, but beyond that, to bridge the gap between the negative positions and the +5, you typically do need a lawyer for that. And that's the role I played for clients over the last 20 years. Now, in my books, you'll see that I often have this chapter called The Best Asset Protection is Not Asset Protection. And what do I mean by that? Well, first, I mean two or three things. One is the best asset protection planning, as I was just sort of alluding to, is not just you go to a lawyer and they create documents for you. That's part of it. But the +5 tools, the best tools you can use are typically insurance, investment, sort of asset type tools that you don't go to a lawyer for. So first, asset protection has to be multidisciplinary. That's the last bullet here. Okay, it has to be, because you can't just get good protection from doing to one type of advisor. You really need a combination of financial, benefit, insurance, and legal all together. Okay. The other thing that's important is the most important tools, and all of them really want to have economic substance. They want to have other benefits other than asset protection. And that's why I was saying the top tools, +5 tools, are primarily not asset protection tools. As an example, I live in Florida. In Florida, we have a tremendous unlimited in value homestead exemption. Well, most people don't think of their home where they live as an asset protection tool. But in fact, in Florida, it is. In some states, like New Jersey, it is not. Okay, very state specific. So you have to do your planning not only in a multidisciplinary approach, there should be economic substance, and it has to be tied to an overall wealth plan. I really don't like people doing their quote-unquote asset protection planning in a vacuum where it's not tied to everything else that's going on. Hopefully you'll see some of that in the next couple of slides. So the first thing we're going to focus on when we talk about protecting is your business, or if you have a law or medical, a practice. Okay? How can we protect the key assets? Now, this is a very important point I'm going to make, especially for those of you in a non-licensed business. What I mean by that is a business like a manufacturing business or a service, anything that's not really a medical practice or a law practice or some kind of professional practice where you need a license to practice that. Okay? That's separate. But for most of your businesses, this is crucial. You have to think about the difference between inside and outside risks. An inside risk is a risk because of the business's activity. So if my company creates widgets, I might have product liability because of that widget. If I have a business that gets into contracts with other businesses, say distribution business, then I might have contractual liability if I don't make good on what I'm doing. They all have employee claims. These are all risks inside that you can't get rid of. I mean, you might get insurance to cover it, but the inherent operation of the business creates those risks. Okay? An outside risk, however, is not anything that happens to do with the business, but an outside risk is what happens if one of the owners gets sued totally unrelated to the business. So let's say I own a manufacturing company. An inside risk would be employee claims, product liability, et cetera, contractual. An outside claim, what if I get sued for a car accident, or I have personal liability, and someone now has a judgment against me and wants to get to my ownership of that business and ideally take it over, and then they own every asset in the business. Inside versus outside risks. Now look at this slide. This is important, and a lot of business owners do not understand this, and it's really fundamental. If you're creating a business, you're an entrepreneur, you have a business in existence, and you use a corporation or an LLC, a limited liability company, I include limited partnerships, but very few limited partnerships out there anymore. So your choice normally is between a corporation and an LLC from a legal point of view. We're not talking about tax, as C, corp, taxation, et cetera, but from a legal point of view. Inside protection. So let's say this product liability. Am I protected if I'm the owner? Well, I generally am under corporate law principles. I wasn't involved in the action, right? This is why, executive at GM would not be personally liable if GM had a car recall and there was injuries to people because of a manufacturing defect. The corporation might be liable, but the individuals inside should not be. And that's true of both an LLC and a corporation under general corporate law principles, as long as they're not personally involved, etc. Okay? But what happens with outside protection? Let's say that I'm an owner of that manufacturing firm and someone sues me and gets a judgment against me. If I own a corporation, there's no protection for corporate stock unless it's a professional corporation, like, say, a doctor. A doctor in most states, okay, a medical practice can only be owned by a licensed physician in that state. So even if you got a judgment against a physician, you may not be able to take their stock in their medical professional corporation. Okay? But putting that aside, let's say, again, it's a manufacturing firm. If someone sued me and got a judgment against me, and I own 100% of the stock in a corporation, they can take that stock. They can take over that corporation, own every asset in it. Okay? If I own 50% or 51%, they can take my percent, and now, yeah, I have a partner, but now they're the co-owner. They may have all the voting rights. Now you get an owner, if you're my partner, who you never knew before and adverse, maybe wants to sell the business, etc. However, with a limited liability company, if it's done correctly and if it's drafted correctly, and those are some big ifs, they do not get inside. They're not at the -5. They're at the +2 in the middle of that scale. They can be kept outside. They can be kept from getting voting rights, kept from management rights, kept from getting any of the assets of that business inside the LLC. So there's a real advantage for setting up an LLC over a corporation. In fact, today, if it's done right, there's really no reason for a company to be set up as a corporation versus a limited liability company today. So if you're sitting there and you're listening to this and you have a business that's a corporation, not an LLC, it makes sense to have a conversation and say, does it make sense to change that? Because from a tax point of view, any way a corporation can be taxed, an LLC can be taxed. With its S corporation status or its C corporation status, an LLC can be taxed that way. So you don't have to give up anything tax-wise to choose an LLC form, and you may get a much better asset protection result from an outside risk. Something to keep in mind. Now, beyond the entity itself, you got to look at what kind of business do you have and what kind of assets do you have. Well, that's what the art of creating an asset protection plan for business is, sitting down with an advisor and getting the right advice depending on what their business is. I've had clients over the years who've had multiple entities and put different pieces of real estate or different assets or different intellectual property, different entities and leasebacks, so that they are not putting all of their eggs in one basket. And that might make sense in your business. It could be equipment, it could be real estate, it could be intellectual property, patents, copyrights, etc. There's no reason to have your most valuable asset inside of your main operating entity that has the most risk. Why not keep it in an outside entity and then lease it or license it to the main operating entity? The operating entity ever has liability or debt problems, etc., you've isolated the key asset so it cannot be taken. Now, cash flow for many businesses, especially small, closely held businesses, from the point of view of the owner, is one of the most important, if not the most important asset. I want to make sure that if the company's ever sued, if there's ever any inside risk, etc., that the cash flow to me is not going to be interrupted or can be protected well. And you see that for a lot of professional practices and small businesses. How do you protect that kind of cash flow? Well, one way is to maximize the protective benefit plans that you can put in place. Qualified retirement plans, which include pensions, profit-sharing plans, 401ks, and a hospital or nonprofit environment, 403bs. These have significant tax benefits. Some of them are tax benefits up front, some of them are tax benefits over time, some of them are tax benefits on the way out. And we'll have another webinar. We've certainly written other articles on the pros and cons of these different types of plans, costs and benefits, and how some give you short-term tax benefits, others gives you long-term tax benefits. Okay, but regardless, a qualified retirement plan is asset protected at the highest level. Okay, there's a Supreme Court case that says from a federal point of view they're protected, and if they're ERISA qualified, which means they're operated according to certain technicalities, which many qualified plans are. And then most state statutes provide a high level, if not an unlimited level, of protection for qualified plans, and many times they include IRAs as well. Now, one of the negatives on qualified plans, and we'll dive a little bit into this today, but we'll spend another more time in a webinar in the future, are the economics, meaning in a qualified plan, you have a deduction today, tax-free growth, and then taxation on the way out. Deduction today, we all like that. Tax-free growth, but full taxation on the way out. So what you're truly doing when you have a qualified plan is that you are trading today's tax rates, because you're not going to get taxed on it because of the deduction, for the future tax rates when you pull it out in the future. Now, is that a good bet? Well, that depends. Here's the history of the U.S. federal income tax from the beginning, and you can see the various ups and downs. Certainly these are in our book, so don't feel like you have to copy this down. And if you put dollars in the 60s, 70s, and 80s where the highest rates were very high, okay, these are the highest rates, and you're taking it out today, you can see there's a pretty good difference, right? I looked at tax return of my father in the late 1970s. He was paying over 70% in income taxes on his last dollars, and now he's pulling it out at less than 35%, okay? That's a good deal for him. Is it a good deal for you? It depends. Where do we think taxes are going to go in the future? Now, we have President Trump, who's been taken office in the last week as I record this, and he has said he's going to lower taxes on the highest income tax earners and really across the board. And that may mean it's a good time not to maximize what you put in your qualified plan, but maybe look at non-qualified plan options or Roth IRA options where you're paying the tax today. Meaning if we get a temporary, a 4-year, an 8-year dip in taxes and then they come back up, that 4-8-year dip would be the time to pay your taxes and fund some good long-term tax savings with after-tax dollars. So we'll see what happens. As I record this, it's in January, so we haven't had anything formally proposed, but that may be a really important long-term tax play over the next couple of years. So with qualified plans, the protection is excellent, and you have to maximize what you put in vis-a-vis your employees. If your business or your medical practice has not reviewed your qualified plan formula and how that's derived, its fees, what are you paying outsiders? We see a lot of old plans that are paying their money manager or their plan TPA extremely high fees when they could be reduced. It's probably worth reviewing that. And depending on what type of plan you have, it could actually create inside risk, meaning you could have as an employer liability as a fiduciary for underperformance of funds. And so you may want to design that plan so that you don't have that responsibility. Now, IRAs are not technically qualified plans, although SEP IRAs are very similar to a defined contribution plan. And IRAs are generally protected across the country, but not always. There is federal protection for IRAs under the bankruptcy statute if you file for bankruptcy and take advantage of the federal exemptions, but those are limited. Certain types of IRAs are limited to $1 million plus or so in protection, and some states give an unlimited protection to IRAs, but some states have a limited protection. I put California here is one of those that has a limited protection in their statute to the amount reasonably necessary for support, which essentially leaves it up to a judge. There are some states that put a hard limitation on it, and there's some that provide unlimited protection. So again, it really is state by state, and we have to evaluate it. So non-qualified plans, I mentioned, these generally go in after tax. So you don't get a deduction today, but they have long-term tax benefit because they grow tax-free and come out tax-free. That may make a lot of sense, and we'll spend another time in another webinar. It makes sense for many clients at all times, and I've been doing this plan myself for a number of years, but especially if tax rates go down, you'll see that these plans become even more popular to take advantage of that long-term growth. And that may be something to look at. And from an asset protection plan, depending how they're structured, they can be structured for the +5 in some states, unlimited level of protection at the highest level, and in some states inside a +2 or a middle of the structure wrapper like an LLC or trust. So it really depends on what type of plan, how it's being funded, and what state you're in. Again, very state specific, very client specific. It's not one size fits all. A captive insurance company. This is a tool that has, depending how it's taxed, could have some tax benefits to it. But what we're talking about here is the asset protection benefits. And if you have a business or a practice and it's buying insurance from its own insurance company, that's what a captive is. And we have captives that are done for the Fortune 100 companies. Every time you buy insurance on your UPS package, that is likely going to their UPS captive company. In fact, there was a important case one level below the Supreme Court where the UPS fought with the IRS from a tax point of view about their captive. So there's lots of companies out there that have captives, but they can even be used by a small business or a professional practice. There are a lot of reasons to do a captive. I could do a whole webinar on captives. They provide risk management, okay, covering risks that a business has no insurance for today. The assets of the captive can be structured for significant protection. You can turn wealth that's in the business that is at a negative position and turn it into a more positive position. However, as I do this webinar in 2017 January, the IRS scrutiny of captives, because there are some people out there who aren't doing it right, and the IRS wanted to look at these in a more close way, means that for many clients, they're taking a wait-and-see approach. Before there's some tax court cases that are scheduled to be published and come out in 2017. We have a new administration coming in, and they may change the priorities for the IRS. So while the captive tool is still being used by thousands of companies, it's still in the tax code, it's something that for many clients they're taking a wait-and-see approach till later in 2017 to understand is this something that makes sense to protect assets and potentially provide some risk management. So those are some business-related thoughts. How you own the entity, what kind of entity you use, should it be a corporation or LLC, inside versus outside, risks, the idea of multiple entities and leasing assets back, the idea of qualified plans and non-qualified plans, and other places you can protect cash flow captives as well. That's all very relevant for successful business, professional practice. Now let's shift gears and talk about personal planning. This could be personal planning for an owner of a business, an executive of a business, a physician, anybody, even someone who's retired or not working. The idea is, what can we do to put some protection around our personal balance sheet, the assets we own personally for ourselves and our family? Now, the first thing clients will ask me, or that we need to address, is, how do I own it? What kind of ways should I title my property so I can get some protection for it? Now, oftentimes, when I have somebody who has high liability, maybe like a specialty surgeon, let's say a real estate developer, someone who really thinks they're going to have liability at some point, they'll say, well, I'm just going to put everything in my spouse's name if they're married. And unfortunately, putting assets in the spouse's name in general, and again, one of the first slides said this is not legal advice, but in general, that doesn't work. Now, certainly I know in some circumstances in certain states it does work. So I've written books with attorneys in different states, in Ohio and New York, in Georgia and California, and I'm a member of the bar in 2 of the states. But it really does depend on the state and the asset and the timing and all of that. But in general, the general rule is you can't just put it in your spouse's name and treat it every other way as a joint asset. As an example, your home. You put the home in the spouse's name, but if you're still living in it, full-time, and you're not paying rent, if it's your income that's paying the mortgage on it, perhaps the property taxes and the maintenance, then it really looks like in every other way other than the title that you're treating it as a joint asset. Well, there's something in the law, a very large concept called substance over form. And if the substance shows that you're really treating it as a joint asset, but the form is you put it in their name, that may not be effective. Or in some cases, it may be effective. And then what happens if that client gets divorced? Are we going to say that they made a full gift to the spouse of that asset and it's off the table, it's not part of the marital dissolution? Well, again, it's hard to argue that it was off the table for creditors, but now, wink, wink, it's really half mine. That is difficult to achieve, and again, in most states, it's not going to work. So in the majority of states, which are not community property states, you're probably going to have assets titled jointly, which means joint tenancy or tenancy in common, and that's generally considered, again, generally as half owned by you and half owned by the spouse. So it's half available to your creditors, half available to their creditors, 100% available to joint creditors. So if you're sued and someone has a judgment against you, half of it could be lost, but vice versa. I don't consider that a high level of protection. That's -3 on my sliding scale, and I typically am explaining ways for clients to move to a better position than that because it's not well protected. Now, in about 10 states, or 15 states, there's an ownership form called tenancy by the entirety. I'm familiar with that because we have that very effectively here in Florida where I live, and tenancy by the entirety in some states for some assets can be very protective if you're only worried about one spouse being sued. So if I have an asset in tenancy by the entirety with my spouse here in Florida and it's properly formed, then a creditor of mine or a creditor of my spouse's has no effect on, there's no impact, no ability to get to a tenancy by the entirety asset. However, if we ever get divorced, if I die, there's a joint creditor, someone who we both owe money to, there's no protection whatsoever. So it can be good in certain circumstances for certain assets in certain states, again, state by state, case by case. For those of you in community property states, any asset that's been acquired generally by the couple during their marriage is considered community property, regardless of how it's titled, and even prior assets can be commingled and then become community property, intentionally or unintentionally, and generally community property is subject to any community debts of anybody in the community. So again, this can be a very exposure-heavy form of ownership, and in the states where you're in that property rule, community property, where that's the rule of the state, you typically have even more challenges to protect assets. So when I'm advising a client, the first thing we're going to look at is what state they're in and what do we have that's exempt. What's at the top of that scale? What's +5? What is truly off the table against future lawsuits and claims? Not only is it the best protection you can get, but you don't have to pay lawyers, you don't have to pay accounting fees, you don't have to pay state fees, you don't have compliance rules, you don't have special taxes. All of things that may be involved when you do a limited liability company or trust or something else, okay? The protection is the best. Okay, so I mentioned there's federal bankruptcy exemptions for qualified plans and IRAs, okay, with some limitations. The states, however, put an additional level of protection, so you don't have to file for bankruptcy to get the protection of a state exemption in your state. It's off the table if it's off the table. But they vary widely. You have homestead exemptions that are unlimited in value in some states, 0 in other states. Same thing with qualified plans and IRAs. Very well protected in some states, poorly protected in others. Life insurance and annuities are protected at a very high level in about 20 states, and in the other states they may have little, if no protection. So it really is important to look at the state rules and build your plan based on what you've got. In almost all states, though, we're not going to be able to use the state exemptions to get +5 across the board on a balance sheet. It's just not possible, even in the best states like Florida, Texas, etc. For those clients, and certainly for clients in other states where we don't have strong exemptions, limited liability companies, family limited partnerships, LLCs and FLPs, are the most common tools we use, the building blocks of asset protection planning across the country. And why? Because they provide a high level of protection if done properly with the proper timing, the proper maintenance, proper agreements, Number two, they allow the client to maintain control of the entity and the asset. And as long as there's no problem, they allow the client to access the asset. So when I talk to clients about protecting assets, one of the things I normally hear from them, they may not say it in this way, but this is what they're getting at, is I don't want to give up control and I don't want to give up access. Well, we can't have everything. We have a cake and eat it too, but if they can feel comfortable that as long as there's no problem out there, they can have access. And regardless, even if there is a problem, they can maintain control, then they're often open to doing some of these legal tools. And LLCs and limited partnerships are the leading ones. Again, I could spend a whole WebEx on this, but the way these tools work are what's called a charging order. The charging order rules that are ideally that are in some degree in the statutes in every state, but there are a handful of states where we have the best law. And if we can use an LLC or limited partnership in those states, we will. Okay? But what the LLC statutes say is that someone who has a judgment against an owner of an LLC or a limited partnership, they can't just get to those assets. They can't become a partner or what's called a member. They can't get voting rights or a right to distributions. They can't force distributions. Okay, so they can't get inside, they can't force anything out, they don't get membership rights or ownership rights, they don't get voting rights. So they get something, but it's not that powerful. Of course, this means the LLC or limited partnership has to be set up and funded before there's a problem or foreseeable problem. It has to have the right language in it. It has to be maintained properly. All of these things need to happen. It has to have compliance, ideally as non-asset protection purposes, as I mentioned before. Okay, you have to work with an experienced attorney who has annual monitoring and annual review of these entities. Otherwise, you won't get the protections I'm talking about. But if you do this right, you can have a very high level of protection while maintaining control throughout the process and even access if there's never a problem. Trusts are another area that I could spend a lot of time on, and these are other tools that provide asset protection planning. But there's really two types of trusts that are out there, two kind of worlds of trust. There's revocable trusts, which are revocable, are changeable, amendable. These are family trusts. You might hear them called a living trust or a loving trust. These are very valuable for estate planning, to avoid probate in your state when you pass away, in case you get incapacitated, for someone to be able to step into your shoes and run your affairs. But if it's revocable, the trust provides no asset protection while you're alive. Great tool, works in conjunction with the will, good for estate planning, but no asset protection. The only creditor protection, the only asset protection you get from trusts are trusts that are irrevocable. That once you put them in place, they cannot be revoked, they cannot be changed. Okay? So that's a big tool. That's a big decision. You're going to put something in an asset, in a tool that you can never change again. Okay? For some assets, for some clients, and for some types of trusts, it makes sense. Well, what if you could put an asset in there that has no value for you while you're alive, like a life insurance policy, like a term policy? Well, that might make sense, and that's what an ILIT is, an irrevocable life insurance trust. What about putting an asset in there that you can still pull an income stream out of? Well, that doesn't sound so harsh. Well, that's what a grant or retained annuity trust is, a GRAT. What about an asset you think is going to go to charity anyway, and then maybe you can get a income stream out of it during your life? Well, that sounds amenable to me. That's a charitable remainder trust. Or what about an irrevocable trust where you can actually be the beneficiary and get to the trust assets when you want? So you can have it protected against your assets, but also get to them. Well, that sounds almost too good to be true. And in our country, for 200 years, it was. You couldn't set up a trust like that, what's called an asset protection trust, or a domestic asset protection trust in the U.S. You couldn't do that until about 15 years ago. You had to go offshore. But now ADAPT, a domestic asset protection trust, is available in about a dozen states or so. So if you're in one of those states and your liability is likely to come in from one of those states, and those states have a statute on the books now that allow this type of trust, that could be an option for you. For the other 40 or so states, clients in those states, probably not the best idea, because you don't have that statute in your state. So again, very customized, very specific. When protecting the home, obviously the best thing you can do is live in a state that has a strong homestead protection for your home. That's not always possible. Some of you may also be able to take advantage of tenancy by the entirety if we're not so concerned about claims against both spouses. That may be not an option for you. If that's not an option for you, maybe a debt shield approach where you don't build up a lot of equity in that home, especially if you can move that equity to another part of your balance sheet that makes sense. We generally don't recommend putting homes, primary residence, in legal structures. Every once in a while that might make sense, but there's some real tax potential negatives to that, and they have to be looked at very seriously before you would go forward and put your home in an entity. A second home, a little bit different. You could put a second home in an LLC. It's not your primary residence. You don't have the same tax rules. Certainly rental and investment properties, LLCs are the key tool here, limited liability companies. So if you've got rental property, if you've got second home, if you've got investment property, raw land, etc., you should be looking at LLCs as a possible tool to own those. So we've gone pretty quickly here, a little under an hour. I try to get a lot of information to you. A minute or two about our firm. I just covered the first bar here, and very quickly, asset protection, the way we work with clients. We are a multi-specialty wealth management firm. You can think of us as if you're using a medical practice analogy, like a multi-specialty medical practice, where you come in and you want to get a full checkup by the cardiologist and the orthopedist and the dermatologist and the gastro, and you get all the different systems looked at by an expert in that field. That's what we can do for our clients, because we've got people with experience in asset protection, like myself, tax, Carol, a CPA with 25 years of experience, corporate structure, benefit planning, retirement planning, insurances, wealth management, investments, all these different areas, college education, funding, etc., state tax management. And we can take our clients through that with different experts working on the areas that they know best in a coordinated way. So if you haven't had that done before, if you haven't had that kind of checkup, either at your business or personally, I'd encourage you to talk to us about it. As I said, we're unique, we're fee-based. We have over 1,000 clients throughout the country. We have this multidisciplinary approach I was just describing. We can be engaged to look at a business. We can be engaged to look at the personal planning. If we're working with the business and tax planning is part of what we're aiming for, if we can't show you at least 200% of our fee in terms of tax savings, we'll refund the fee. That's pretty unique. For a lot of our individuals and their families, we're doing all this so people can achieve their goals, so they can reduce the stress of trying to get to their financial goals. And you'd be surprised about how coming through this process and having a real plan in place and having experts look at everything will reduce that stress level. So in terms of next steps, as I mentioned at the beginning, this is the beginning of an education process. Certainly we have articles we'll be doing for MultiBriefs and their clients coming forward. Certainly you should all get copies of these books because they're for free. And whether you want them in a hard copy, we'll send you a hard copy. If you like them in Kindle, we'll give you a download form for Kindle or for iPad. If you look at the bottom right of this slide, go to ojmbookstore.com and use the code MLTWEB at checkout. So you'll see a price point. We sell these books. But because you're listening to this through MultiBriefs, you're going to get it for free. You just have to use that code. When you get to the checkout, you'll get it for free. In addition to reading and learning more, if you want to talk to me, have questions about what I've mentioned, here's my email, mandell@ojmgroup.com. We always talk to people and explain what we do and hear about their situation and try to see if there's a fit, and we do that. We do it for free. So I'd encourage you to come to ojmgroup.com, learn more about us, go to the bookstore, get the book. If you go on our main website, ojmgroup.com, you can see a free consult page. You can fill that out. We'll set up a consult. We won't charge you for it. We'll see if there's a fit. So again, I thank you for listening. We've gotten this done in a little less than an hour. If you thought it was valuable, certainly give some good feedback to us. Certainly reach out to me, get copies of the free books, and hopefully we'll see you again on another webinar from MultiBriefs and all of their clients in the near future. Thank you.